reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. You have heard testimony of eyewitness identification. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning the credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, you may also consider 1, the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation and the conditions at the time of observation, including lighting and distance. 2, whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. 3, the circumstances under which the defendant was presented to the eyewitness for identification. 4, any inconsistent identifications made by the eyewitness. 5, any instance in which the eyewitness did not make an identification when given the opportunity to do so. 6, the witness's familiarity with the subject identified. 7, lapses of time between the event and the identifications. 8, whether the eyewitness and the offender are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. 9, the totality of circumstances surrounding the eyewitness's identification. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, the jury is not to discuss any questions that a juror wrote that were not asked by the court and must not hold that against either party. 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. And so these are the verdict forms that will actually go with you back to the jury room, and I'm going to read through them with you at this time. Verdict form number 1 has the name of the court on the very top, case number, State of Florida versus, and there's a misprint, it says Domingo Rodriguez. I think that should be Domingo. So we will have that edited prior to sending that back to the jury room. But it's the State of Florida versus Domingo Rodriguez, and it says aggravated cruelty to animals. We, the jury, find as follows, as to the defendant in this case. And then it says check only one. And then there's an A, a B, and a C. And a spot next to each letter for you to mark your one choice. A reads, A, the defendant is guilty of aggravated cruelty to animals as charged. B reads, B, the defendant is guilty of animal cruelty as included. C reads, C, the defendant is not guilty. And then it says, so say we all. And it says foreperson of jury. And right above that line is where the foreperson will sign this document. And right below that it says print name of foreperson of jury. So the printed name of the foreperson will be placed on that line. And then the date of the verdict is placed right below that. And if you reach your verdict today, the date is February the 21st, 2025. That's verdict form number 1. And again, will be amended to correctly spell the name. This is verdict form number 2. Name of the court at the very top. Case number, State of Florida. And it will read versus Domingo Rodriguez. Unlawful disposal of dead animals. We, the jury, find as follows as to the defendant in this case. And again, check only one. And here you have two choices, an A and a B. And whichever one of those you choose, you put your mark next to it in the corresponding space. A reads, the defendant is guilty of unlawful disposal of dead animals as charged. B reads, the defendant is not guilty. And then again, so say we all, signature of the foreperson appears right above this line. Printed name of the foreperson of the jury is placed right on this line. And then the date of the verdict is placed here. And again, today's date, if you reach your verdict today, is February the 21st, 2025. So if we could have those verdict forms corrected. And then single defendant, multiple counts or informations. A separate crime is charged in each count of the information. And although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Does the state wish to give a closing argument?
Yes, Your Honor.
You may proceed, Mr. Newell.
May it please the court?
Yes, sir.
Counsel, members of the jury. Dexter was found in April 2024 in the city of Clearwater, tied up to a street post. He was brought to Pinellas County Animal Shelter, where he stayed there for about a month before he was adopted. He was adopted by this defendant, Domingo Rodriguez. You saw the video from Pinellas County Animal Services of Domingo Rodriguez walking in, going up to the desk, filling out the paperwork. You saw him walk out of that building with Dexter. You saw him put Dexter up into a crate in the bed of his truck and drive away. You can see Dexter in those videos. He's wearing a comb, wagging his tail a little bit, tromping along next to his new dad. But Dexter doesn't know that his life is going to end within the next 12 hours. Because the next day, on May 11th, 2024, this defendant, in the same truck that he's driving at Pinellas County Animal Services, he's driving that same truck out of Fort De Soto. He's by himself. Nobody else in the car, nobody in the front passenger seat, nobody in the back seats. He's got a cooler that's big enough to fit Dexter's body in his truck out of Fort De Soto the very next day after he adopts Dexter. And then 3 days later, Dexter's body is found floating in a clear plastic bag out of the mangroves at the east tip of Fort De Soto Beach in a secluded area of Fort De Soto Park. His body, his head is decapitated from his body, he's decomposed, and he's just floating around in the mangroves. That is why we're here today. We're here today because of an aggravated animal cruelty case. And what does that mean? The judge just instructed you on the elements that we need to prove today. But there's multiple counts, and in order to prove all these counts, I'm going to start from that count number 2 and work our way up to count number 1. So count number 2 is this: the unlawful disposal of the bodies of dead animals. So for this charge, there's one element: that Domingo Rodriguez disposed of the carcass of any domestic animal by dumping such carcass on any public road or right-of-way, or in any place where such carcass can be devoured by beast or bird. What's important here is that last sentence, as well as the domestic animal. If you remember, whenever Dr. Perlman was up here giving her testimony, I think it was yesterday, I asked her kind of at the very end, is a dog a domestic animal? Dog, she answered yes, a dog is a domestic animal. And then for the end of that, in any place where such carcass can be devoured by beast or bird. We brought you witness testimony from Jared Bristol, the fisherman, as well as Mark Warchola, who's the park ranger out of Fort De Soto, who went out to the scene. It may have seemed silly, it may have not made sense whenever we were asking those questions, but I hope it makes sense now while we were asking certain questions. What kind of animals are over in those mangroves? All kinds of different crabs, raccoons. What about the water? There's fish. What about birds? Are there birds out there? Yes, there are birds. You heard testimony that there were holes that were in the bag that Dexter was found in. Those holes gave access to these other animals. So the reason why we're asking those questions is because we knew we had to prove this part of this charge. You saw the video, and you'll see the video again whenever you go back and deliberate, of Mr. Rodriguez, the defendant, driving into Fort De Soto 3 days before Dexter's body is found. That's how we know that he's the one who did it. And I'm going to talk more about ID and identification as we move forward, because as you know, we don't have any direct evidence, we don't have anything that shows Mr. Rodriguez cutting the dog's head off, we don't have anybody saying, yeah, I saw him do it, but we're going to piece together that puzzle together. And the way we do it is we start with this charge. Mr. Rodriguez's dog was found out at Fort De Soto Beach. And it was in a place that can be, where that body could be devoured by beast or bird. I'm going to explain the verdict forms to you briefly. Because these verdict forms, there's 2 of them, and I don't want anybody to be confused. So the first page is going to look like this. Obviously, his name is going to be spelled correctly. Second page is going to look like this. So that charge that I just talked about is the second page, the unlawful disposal of animals. If you believe that we've proved our charge beyond a reasonable doubt, which we have, we're going to ask you to mark Section A. Section B is not guilty. The second verdict form brings me to that first charge, the aggravated cruelty to animals. Now, if you remember, Judge Meyer was just instructing you about how there's a lesser included offense. So this is not as simple as just guilty or not guilty. The first option is going to be that the defendant is guilty of aggravated cruelty to animals as charged. Second option is the defendant is guilty of animal cruelty as included. And the third option is the defendant is not guilty. Now, if the charges, whenever Judge Meyer read them to you, of aggravated animal cruelty and animal cruelty sounded similar, it's because they are. The aggravated cruelty to animals is just a heightened version of the animal cruelty. And in those instructions, if you believe that we've proved aggravated cruelty to animals beyond a reasonable doubt, that's where your inquiry stops. If you believe that we have not proved that charge, but we have proved the lesser included of animal cruelty, then that's your choice. If you don't think that we've proven anything beyond a reasonable doubt, then it's not guilty. But I just want to be clear so we don't run into any problems, that this verdict form, it says check only one. So it's not A and B, it's going to be just A. For that aggravated cruelty to animals charge, we need to prove two things. For the aggravated cruelty to animals charge, we need to prove that Domingo Rodriguez intentionally committed an act to an animal, or owned or had custody or control of an animal and failed to act. And number two, Domingo Rodriguez's act or failure to act resulted in the excessive or repeated infliction of unnecessary pain or suffering to the animal or the animal's cruel death. And we've got a definition of cruelty. Based on the facts that we have, I'm not going to go too much into the definition of cruelty because at the end of the day we have a dog that doesn't have a head on. I'm going to talk a little bit about how this was intentional and how this was excessive or repeated infliction of unnecessary pain or suffering to the animal or led to the animal's cruel death. You heard testimony from Dr. Perlman. She testified and she did the show and tell in front of you all with the bones. She explained to you all that there were 4 impact marks. Not 1, not 2, not 3, but 4 impact marks that she was able to determine based on her examination of those bones. She explained to you that one of those impacts had what's called a hesitation mark, where there wasn't enough force that was brought down the first time. This was not an accident. There was 1, 2, 3, 4. It was on purpose. Dr. Perlman also told you that there was no possibility that an animal could have done this to Dexter. It was a human being with a sharp object, either a machete or a meat cleaver, that caused those injuries to that neck area. That's how we prove. And the 4 times, that's the repeated infliction of unnecessary pain or suffering to the animal. Whenever we're talking about intentionally committed, those kind of go hand in hand, because it wasn't just 1, it was 4. She also testified that that hesitation mark, that first impact, could have caused Dexter to be paralyzed. And that's very important in this case, because she does not have the whole rest of the body to complete her analysis and determine the cause of death. But I want to emphasize something to you all right now. Dr. Perlman, what she was able to look at was everything from Dexter's neck down, external and internal. She looked at his heart, no issues. She looked at his lungs, no issues. She looked at his stomach, no issues. She looked at his spleen, no issues. She looked at his kidneys, no issues. She looked at his intestines, no issues. She looked at his bladder, no issues. She looked at his bones, no issues, no broken bones, not even a bruise on Dexter's body. For all intents and purposes, Dexter was a healthy dog, minus the kennel cough that he had, the doggy cold. My argument to you all is that Dexter's head was likely in the same state as the rest of his body. That if Dr. Perlman had the opportunity to examine Dexter's head, that she would find that he was, from the neck up, as healthy as he was from the neck down. But unfortunately, we do not have Dexter's head in this case. Criminal defendants are in a very unique situation, in a unique position, where they are able to determine what evidence is left behind. And in this case, there's no head. And we know that this defendant tried to hide evidence and get rid of evidence when he took Dexter's body out to Fort De Soto. And I'll get more to that later, but I want you to keep that in the back of your mind, because that's how we know that it was this defendant who did this act to this dog. I'm going to talk to you some more about some facts that are not in dispute in this case. And these are facts that lead us to know that this defendant is the person who did this to Dexter intentionally, excessively, repeatedly, and on purpose. Fact. The defendant went and adopted Dexter on May 10th, 2024. Video evidence, you're going to have paper evidence, all the adoption forms, all the adoption paperwork. His name's on it. He's the one who went there. That's fact. Fact. The next day, on May 11th, 2024, the defendant is seen entering Fort De Soto Beach. Fact. On May 14th, 2024, Dexter's body is found at Fort De Soto at the East Tip Beach. That's fact. After the defendant had already left Fort De Soto Beach, he was on the phone with Animal Services. They called him. Remember Jesus' testimony yesterday. Mr. Rodriguez, he did not call Animal Services to tell them anything. Animal Services called Mr. Rodriguez, and Mr. Rodriguez told the Animal Services that Dexter had escaped and that he had been looking for Dexter. That's after he left Fort De Soto Beach. That's a fact. There were 4 impacts to Dexter's neck, and those impacts, those were cuts on Dexter's neck that were caused by a human being. Those are all facts that are not in dispute. And when you're looking at this case, and when you're making a determination in this case, you cannot just look at 1 fact or 2 facts or 3. You need to take everything into consideration, which is why I started with the body being found out of Fort De Soto first. Because it begs the question, why was he out there? Why was Mr. Rodriguez out at Fort De Soto Beach on May 11, 2024? Was it because he was going fishing? Was it because he was looking for the dog like he told Animal Services? That doesn't make sense. And what an unfortunate coincidence it must be for Mr. Rodriguez that the place where he is at, the day after he adopts a dog, that 3 days later, that same dog is found dead, decapitated, floating in the water, out at the same park that he was at 3 days prior? It's not a coincidence. Those facts indicate that there is something much more sinister going on in this case. These are facts that indicate that the defendant was trying to cover his tracks, that he was trying to hide evidence. That's how we know that he is the person who is responsible for Dexter's death, and that he is the person who's responsible for cutting Dexter's head off those 4 times. Because that's what's reasonable whenever you look at all these facts together. Because if there was some accident that happened to Dexter, or if Mr. Rodriguez had stumbled across and found Dexter, wouldn't he have called Animal Service and said, hey, this dog I just adopted, this is crazy, his head is chopped off, I don't know what's going on? That's what Jared Bristol did whenever he found the dog out of Fort De Soto. Immediately called 911. Hey, there is a dog here, and it doesn't have a head and it's floating in the water. That's what's reasonable. What's not reasonable is to say that you're out looking for the dog, driving up and down the beach, because that cell site data, whenever you get to take that back with you, whenever Ms. Shapiro testified, you're going to see all those timestamps, you're going to see all those places where he was. And it wasn't just going from home to Fort De Soto. That map is going to show you that Mr. Rodriguez, he went to his house, he went over to Gulf Boulevard, drove down the beach, came over to Fort De Soto, went down to Fort De Soto, came back up, went back down to Fort De Soto, and then he leaves and goes home. That's what that map is going to show. Mr. Rodriguez was looking for a place to hide the body. He was looking for a place up and down the beach. He wasn't going fishing. There's plenty of spots for him to go fishing up and down Gulf Boulevard. Plenty of places for him to park, go out to the shore, go out to docks, go out to piers. That's not what he did, because that's not what was happening. He was looking for a place to hide the evidence of the crime that he committed. And then what happens whenever Mr. Rodriguez is confronted with this knowledge that, hey, the dog has been found out at Fort De Soto Beach, a place that you were at 3 days ago? He must have got out. He got out, he escaped, I was looking for him. I want to talk about those 2 statements in particular. He must have escaped. This is the gate and the hole underneath the gate and the fence that the defendant says that Dexter slipped through, that he escaped through. Now remember, the testimony that we heard throughout this trial is that Dexter was wearing a cone. I would argue that even without a cone, Dexter would not be able to fit under this gap. The other thing I want you to pay attention to is that it's not like it's dirt that's down here where he could have dug a hole and given himself a little bit more space because he really wanted to get out of that yard. It's concrete. There's no way for Dexter to have slipped under that fence like Mr. Rodriguez says he does. That is another fact in this case. That's how we know that that statement is untrue. I went out and looked for the dog. I was looking for it. This green flash drive is State's Exhibit 16, okay? It is the video, you saw part of the video from the neighbors yesterday whenever they were testifying. This is the ring camera from that neighbor who we had her video up and playing. So we showed you a part of it, but there's several other videos. Why this is important is because I want you to go and watch all those videos whenever you're back and deliberating. Because it's not just that one video, there's, like I said, there's several of them. You heard testimony that that camera catches motion, and that's how it alerts somebody like, hey, there's something that's on this, and that's why you need to download the video, and that's why she gave it to law enforcement officers. The first video on there shows a male lady who is across the street walking slowly, and that is the motion that set off the ring camera to say, hey, there's motion outside of your house. So it is reasonable to believe that somebody who lost their brand newly adopted dog would be moving at a much higher speed, frantically looking around, making a whole lot more movement than a male lady who's walking across the street. That's some motion that would be captured by that camera, and there's none of it. On all of those videos, you are not going to see Mr. Rodriguez going up and down the street. You're not going to hear anybody yelling, does anybody see my dog? Whistling, trying to clap their hands, get the dog to come back. You heard no testimony that they were knocking on any neighbor's door. Hey, did you see my dog? That's reasonable, but that didn't happen. It did not happen because Mr. Rodriguez never looked for the dog, because he knew what happened to the dog, because he's the one who inflicted that harm on Dexter. It's an inconsistency with his story, and it's backed up by facts. Now, these neighbors who testified, you heard testimony like that one of them had a Justice for Dexter sign in their yard, so maybe there's some bias there. I will give it that. But there's no bias on video. It's black and white, well, it's not black and white, it's in color, but it's clear as day that Mr. Rodriguez is never going up and down looking. So their testimony is corroborated by that evidence. And that's why you should believe what they're saying whenever they said, he never came to my house, nobody was out there looking for Dexter, nobody was calling the dog's name. It's corroborated by evidence that is, it's facts. You can see it for yourself. While I'm talking about the videos, this is a jury laptop. It's going to go back with you whenever you go to deliberate. This is an old piece of government technology, all right? This is what you're going to use to view the evidence. And Judge Meyer just said that the first thing you're supposed to do whenever you go back there and deliberate is pick a foreperson of the jury. The second thing that you should do is get that computer out, start booting it up, and plug it in, because it does not have good battery and it takes a while to boot up. Whenever you're going through the evidence with the discs and with the flash drives, I also recommend that whenever you plug it in, you drag it off of the flash drive and download it to the computer. That way you can actually view the evidence quickly, so it doesn't have to, the computer doesn't have to talk to the flash drive or talk to the discs. That way you can actually view things in an efficient way. Something that was discussed at jury selection, and I promise I'm almost done, was that the state does not have to prove motive in this case. And frankly, we don't have an answer for why Mr. Rodriguez did this to his brand new dog. I don't want to know what was going through his head whenever he decided to do this to his dog. We may never know what was going through his mind whenever he did this to his dog. But at the end of the day, we need to prove those two elements of the aggravated cruelty to animals and then the unlawful disposal of dead bodies of animals. The way that we've done that is by sort of working backward to forward. From the start of the investigation, at the end of whenever Dexter was found, seeing Mr. Rodriguez pull into Fort De Soto with a cooler that's big enough to fit Dexter in it, to Mr. Rodriguez's inconsistent statements, to the time that he went and adopted Dexter. That's how we proved in that case. That's how we've proven that Mr. Rodriguez was covering his tracks. He was trying to hide the evidence, and he didn't think he was going to get caught. So imagine his surprise whenever law enforcement officers show up to his house and say, hey, your dead dog got found. That's when he starts to panic. That's when he starts to make those inconsistent statements. We ask that you find Mr. Rodriguez, this defendant in this case, guilty on all counts. Thank you for your time this week.
Thank you. Does the defense wish to give a closing argument?
Yes, Your Honor.
You may proceed.
May it please the court,
Yes, sir.
counsels. Members of the jury, good morning. This case is undoubtedly tragic. A life was lost, the life of a dog named Dexter. We understand and appreciate the gravity of the situation, the sympathies, the disgust. We too want justice for Dexter. Nobody wants to see this happen to any dog, any animal, for that matter. This is a serious case, no doubt about it. These are serious allegations. But that's why your role in this case is that much more important. Because when it comes to a tragic case like this, there has to be proof. The state has the burden. No, the public duty and the obligation to prove my client killed this dog. And they have to do it beyond all reasonable doubt, the highest burden in our justice system. This is tragic. But what's more tragic is wrongfully convicting an innocent man when there's no evidence to support it. No evidence as to who, the what, the where, and the when. At best, they have suspicion. That's not reasonable doubt. That's not guilty. Justice for Dexter, absolutely. But justice for Domingo Rodriguez, too. And while it is understandable to seek justice for such a loss, justice must be based on the facts, not speculation. Justice must be built upon the foundation of evidence, not guesswork, not bias, and certainly not suspicion. Suspicion is speculation, and speculation is nothing more than imagination. You know what the state is asking you to do? Use your imagination, because the facts are not there. Even the doctor said there's a lot of missing pieces to this puzzle. I wrote it down because it was so important. There are, in fact, missing pieces to the puzzle. That's their fault, not ours. They had to put the pieces together to establish a picture of guilt, and they have failed to do that. They're asking you to use your imagination to fulfill and find every element of this offense beyond all reasonable doubt. Members of the jury, this is not fantasy land or Wonderland. This is not a game. The state has stranded you on a game board and has burdened you with choosing from a whole bunch of possibilities. It's Colonel Mustard in the kitchen with the wrench. This is not Clue. You guess wrong in the game of Clue, you keep playing. No harm, no foul. You guess wrong in this, the real world, when we need facts, when there's a government system in place where they have the burden of proof, it's no harm, no foul. An innocent man's life and liberty is at stake. This is serious. This is not a game. And shame on them for putting you in a position where you have to use your imagination.
Sustain the order.
They're putting you in a position to use your imagination. Dr. Perlman, I can't, it's out of my expertise to pick exactly which weapon was used. They're putting you in a position where you have to choose and fill in the gaps for them. That's not how this works. They're asking you to use your imagination as to who did this. Nobody knows. Their lead case agent, I asked him, is there any direct evidence that you have against my client? No. Okay, how about indirect? It's the exact question I asked him. No. They're asking you to use your imagination as to where these crimes occurred. Nobody knows. They're asking you to use your imagination as to who did this. Again, nobody knows. Not one person out of the 20+ people that they brought in here was able to say, that guy right there is the one who did it. On the contrary, what they did, that's my neighbor, that's my father, that's my family member, that's the guy who adopted the dog. We know that. But not one person raised their right hand and said, remember the jury, that's the man who did it. Not one person. That's lacking. So when the judge instructed you, it's not about the amount of witnesses. I thought for a second they were going to bring everybody in Pinellas County here to ask them if they did this. It's not about how many people came here to testify. It's about the quality of the evidence. And guess what? To be quite frank, all those 20 people said a whole lot of nothing. You heard a lot of nothing from Detective Payton, digital forensic analyst, lead case agent, Deputy Rosenberg, forensic veterinarian, Dr. Perlman. And we'll get into, the specifics of their testimony in just a bit. And the 20 other people they brought before you. But let's consider what Detective Payton said. It's pivotal in these types of cases. Who, what, when, and where. Let's use that as a roadmap as I continue with my closing argument. I even asked Detective Payton, okay, you'd agree with me that in regards to these questions, who, what, when, and where, we have no answer. You know what he had to admit to us? Right, we don't. Again, Deputy Rosenberg, the lead case agent. Do you have any direct evidence? Indirect? No. Dr. Perlman, do you know cause of death? I don't. Can't. The dog was dead before the decapitation occurred. The state has to prove that this was done to a live dog. It falls apart. Their own witness told you that the dog was deceased prior to the decapitation. Their star witnesses were actually our star witnesses. The state carries the burden of proving this case beyond a reasonable doubt that my client intentionally committed an act that resulted in the cruel death of this dog. That's a heavy burden. Now I want to direct your attention to jury selection. You have to ask yourself, are you in any better position than you are now when this case began? Even the judge told you and gave you the example. No evidence is presented. If you had to find a verdict right now, guilty or not guilty, what would it have to be? Not guilty. Numerous people answered the question. It was asked, does anybody have a problem with that concept? Everybody agreed. You swear to uphold the law and the judge's instruction in this case. You heard it from the judge himself. You have to find the defendant not guilty. What has changed since that statement was made, that conversation at jury selection was made? What has changed between that time and now? Nothing. As a matter of fact, you're in a worse position than you were when this case started. Because I'll level with you, there's always a curiosity, accusations, charges. I get it. But you've heard from everybody here so far. The case is closed. This is the evidence. And nobody is able to determine that it was my client who did this. They're asking you to make a lot of jumps in this case because all they have is adoption, seen at the park, and he made some conflicting statements about how the dog escaped. That's it. That's it. You take those three things, and now they want you to jump, and say, no, he did this. He intentionally committed cruelty, committed decapitation. Members of the jury, let's use common sense. They're basically essentially asking you to find my client guilty because he adopted the dog. That's like finding a husband guilty of murder solely because he was married to, of murdering his wife simply because they were married. That makes no sense. Again, there's nothing linking my client to these crimes. No eyewitnesses, no video footage showing what happened, no forensic evidence, no DNA, no fingerprints, no weapons, zip, zilch, nada, nothing, nothing. They brought you and put you in a patchwork of speculation. I want to talk about the where and the when. Where the dog was found. We heard from the young fisherman, the young man who found it. He testified that the bag could have been drifted and came from anywhere. Even from the Sunshine Skyway Bridge. The tides move unpredictably. They come in, come out. Yet the authorities that said, nope, this is where it is. They got rid of common sense almost immediately. Even the young man, wisdom, wise young man said, you drop a can in the waters, you think it's going to stay there? Remember the jury, that bag was not left at Fort De Soto. It ended up in Fort De Soto. They scrutinized my client's visit to Fort De Soto Park. He told the authorities that sometimes he does some unofficial driving and he took 3 men there. Take a look at the video. The deputy had to admit to me when pressed, yeah, you can't really see in the back. There's 4 doors to that truck, members of the jury. They immediately dismissed his explanation, claiming that there was no passenger seen. That's contradicted by my cross-examination. How about the when? Dr. Perlman spoke at length about decomposition. I questioned her extensively about decomposition. She can't tell you when this dog died. Can't tell you when decomposition started. The state wants, no. The state needs you to believe that this happened on May 11th. Because without that, I don't know what else to say. They need you to believe that this dog was dropped off at Fort De Soto Park on May 11th. But what about the 12th, 13th, the 14th? But once they set their eyes on my client, the easy target, well, he adopted him, well, then let's narrow this investigation. I don't care about any other cameras in the toll booth. I don't care about anybody else. We got our guy. This is it. Case closed. It's done. Did they do any investigations around the park about witnesses? Did you see anything on the 12th? About the 13th? About the 14th? Nothing was done. And the reason that this is important, especially when we talk about decomposition, right? Because when you take into consideration the warm waters, it's in May, the humidity, the temperature, the clouds, decomposition is accelerated. The state wants you to believe that, no, it's the 11th, and that's, for 4 days, it was decomposed. No, member of the jury. It's probable that somebody dropped this dog off, God knows where. Literally, God knows. Nobody else in this courtroom. And if the state knew, they would have force-fed that to you. Only God knows where this dog was dropped off. And it decomposed, accelerated, because of the warm temperatures, the warm waters, especially in Florida in May. So the decomposition could have started the 12th, the 13th, or even the same very day. Look at the picture. You think that there's air conditioning in that animal control car? They had the dog wrapped in a black bag. It was decomposing on the way from Fort De Soto Park. When it got to Dr. Perlman, God knows how much it had already decomposed. There's no way of saying that the 11th was the day. Or even the 10th for that matter. She was unable to say cause of death. That's the reason why we're here. That's the reason why the state has charged my client. He did this. And she told you, their doctor, I don't know what caused this dog's death. I don't know what else to say. How about the cooler? Members of the jury, I'd argue that's a red herring. If you don't know what a red herring is,
Objection.
Sorry? Objection?
Improper argument, Your Honor.
Oh,
that's a red herring. That's a distraction. No, members of the jury, they want you to take a look at the picture. No, the cooler. Look at the cooler. Remember the jury, if the cooler was so dang important, why didn't you swab it for DNA? Why didn't you check it for foreign hairs and substances? Why didn't you check it for fingerprints? Why didn't you bring the dang cooler to the courtroom? Open it up, beer and ice. Okay. But they made a big stink about it. And they try to get away with an explanation. Oh, well, it's multiple days had passed. Yeah, you claim that this dog was dropped off on May 11th, but you still swabbed its paw because you saw some discoloration. So why that, but not for the cooler? Doesn't make any sense. Makes zero sense. You're starting to see a zero has been a big theme in the state's case. I asked the deputy just to make sure, hey, did you smell anything? Is there bleach? Did you see anything? Did you take measurements? Because if you're going to make assumption and bring serious allegations that mention that the dog could have fit in this cooler, well, let's take measurement. Let's do the things the right way. We're the state of Florida. These are serious allegations. Let's take our job seriously. They didn't do that. Don't get distracted by the cooler. Because if it was very important, it would be here right in front of you. No smell of decay, no smell of bleach, nothing unusual. No evidence, there's no questions asked, nothing about a cone at the house. The house was clean. No weapons, no meat cleavers, no machetes, no nothing. But they got their guy. This is it. but they took trash bags. They analyzed the trash bag, and if you want to give that credence, same trash bag that you could, trash bag there in that courtroom that has a knot on it. You can find a trash bag like that at Publix, Winn-Dixie, Walmart, anywhere. No fingerprints, no nothing. But they took the trash bag, not the cooler. They had a forensic tech, they measured the trash bag. You saw that. And even after their analysis, there's no match, nothing to, of course there's no match. You go to practically anybody's house here in Pinellas County, they're gonna have a trash bag that looks like that. And let's use common sense. Here in Florida, a lot of fish, crab, raccoons, you heard that from the state. And there was holes in this bag when it was found. You'd think if a deceased animal is floating in the waters of Tampa Bay, it's gonna be in the peace and the condition it was found after 4 days. Fish would have got into it, sharks, other animals. The skin was still on the animal when it was retrieved, which means that the dog was not left there the 11th. If it was there the 11th, the 12th, the 13th, or the 14th, you would see signs of fish, animals trying to get to it. Birds. Heck, they brought a charge of improper disposal that could be left in a place of, that could be devoured by bird or prey. So you're telling me for 4 days nothing touched this animal? I'd argue that things started getting into the bag. That's why there's holes in it. I guarantee you, if that animal was left on the 11th, like they need you to believe, we wouldn't even have anything to have examined. It would have been gone. Use your common sense, members of the jury. The state also made mention, dog was fine. We don't know that. Dr. Perlman did not send the liver and the gastric content for toxicology. I asked her, is it possible the dog could have ingested rat poison or poison? And by the way, every time that I try to ask her a simple question, it was just a long explanation. A whole lot of nothing, like every one of their other witnesses. But she says, no, her best explanation was, no, gross evidence. It's a big word. It just means looking at it with your eyes. That's not science. Science is sending it out for examination. She didn't send out any biological samples. She didn't send out any toxicology. God knows what a toxicology report would have discovered. Rat poison, eating something. Dogs can't eat blueberries, onions. Nothing like that. Chocolate. A tail all this time. Dogs can't eat chocolate. Nothing was determined what this dog ate while it was roaming the streets. Who fed it? Those are reasonable questions. What would a toxicology report have shown? It was never said. We have a decapitation case, of course. But obviously, the decapitation was not the cause of death. So what was? Don't you think it would have been prudent to further analyze? Give us an answer? You deserve an answer, members of the jury. And it was their job to give it to you. And instead, they've left you with more questions. I agree with the state, at least in one thing, they don't have to prove motive. by golly, if there was motive, they would have let you know about it, for sure of it. They don't have a why. They don't have a how. They don't have a where. And they don't have a who. They can't put my client behind a knife, a meat cleaver, a machete. They can't. If you use your imagination, maybe, but that's not what the law says. You have to rely upon the facts and the evidence as they were presented in this courtroom, nothing else. You can use your common sense. The judge is never going to tell you that you have to leave your common sense out there in the room back there. You can use it. But to further support their case, they brought witnesses from the neighborhood. Bias, they had to concede that. They have an interest in this case. How do we know they have an interest in this case? Their questions were prepared for them. They had yard signs protesting my client's face in front of their house. They want you to find my client guilty. Of course they're going to testify in accordance with what they need. But again, their best case is he said he was looking for the dog, and the video camera doesn't show him looking. He must be guilty. He said he was looking for the dog and he did it. That's it. I don't need any more. The state, stop bringing witnesses. I'm done. I'm convinced. That's not how this works. There was a double standard in this case. The state paraded my client's family members, his wife, onto the stand. And it was so embarrassing, even the state had to excuse themselves when they asked, "Did you do this?" Come on. Come on. That's how you know their state is so weak. They know it. No, we got to exclude other people from doing this. That's absurd. And they want you to believe. No, when his family members say they didn't do it, you need to believe them. But when my client says the dog escaped, you should consider him a liar and find him guilty. What a double standard. Believe his family members when they say they didn't do it, but when my client says something, don't believe him. He's guilty. That's hypocritical. We saw some adoption workers come in. They had to admit there's no verbal aggression, physical aggression shown with the dog. And again, three people to say that he adopted a dog, we get it. It's a crazy world out there. But that's not reasonable doubt. We have a lot of suspicion. And they're banking on it. They don't want you to look at the facts of this case. They don't want you to look at all the doubt. Recall during their case in chief, when they showed you one of the first videos, an 8-second video, 8 or 10 seconds of just my client and his car going through in and out of Fort De Soto. I made it a point to bring in the whole video. It's in there. It's in evidence. You're going to be able to see it if you want to. About an 8-minute video. I made the point. Show the whole thing. Show the other cars coming and going. Was there an investigation as to the license plates of those cars? Were those people questioned? No. They just want to show you what this whole case has been. They're very narrowed in. They only wanted to show you what they need you to believe. They don't want you to see the whole picture. It was me, the defense, that said, no, let's bring in the whole thing. What the state has given you at best is a hunch, an assumption, a theory based on a fallacy. There's classic formal fallacies, logic. Here's a good one. The vet can't find any reasonable explanation for why my dog died. See? That proves that you poisoned him. There's no other logical explanation. That's a fallacy. That's illogical. That's a jump into conclusion. That's doubt. Remember, reasonable doubt applies to every element of the offense. If you have reasonable doubt as to one part of an element of the offense, you only need one. Not guilty. That's what the law requires. Suspicion is not enough. Throughout the trial, I noticed a little tension, a little eagerness, maybe a little excitement. Oh, the forensic technician's coming. This must be the part where we get the facts. I saw some scribbling. I saw, okay, ears pricked up. And after the forensic tech testified, nothing. Oh, the forensic veterinarian, okay. I felt it. She testified. Detective, digital forensic analyst, decapitated. Okay, here it is. Here it comes. 5,000 messages, couldn't find anything. There was a gap in history, but it could have been many things. Updates. That sigh, that anticlimactic feeling of, wow, there's really nothing here, that's real. That's reasonable doubt. This is the main charge. You have it in your packet. It's going to be sent back with you. One thing that's not explicit in these instructions is that you have to prove identity. That is this name right here, my client, Domingo Rodriguez. You got to have some facts to hang your hat on that it was my client that did this. Not that my client adopted the dog. My client did this. There's no facts. So it's not Domingo Rodriguez. Intentional, that's a strong word. Intentional acts. What evidence do you have presented before you that he intentionally, my client, did this? None. Their best evidence is that the doctor said there was multiple hacks. The same doctor who said that the dog was already dead and we don't know the cause of death. If you don't know the cause of death, that means the decapitation was not the cause of death. She said that. She confirmed that. Look at your notes. Decapitation is not the cause of death. That's the only reason why we're here. So there's nothing intentional. The act. What was the act? There's a bunch of possibilities as to what happened. It's a crazy world out there. We have no idea. And I argue that the other option, owned or had custody or control of an animal and failed to act, there's been no evidence that he failed to do anything. It's not criminal to not look for your dog. And there's nothing in the instruction that's going to say that. Nothing in the law that the judge is going to give to you. And then you have to look at element 2. So if you have any reasonable doubt as to Domingo Rodriguez, or intentional, or the act, the law requires not guilty. Domingo's act or failure to act resulted in excessive or repeated infliction of unnecessary pain or suffering, or the animal's cruel death. We don't know what the death was, so it can't be cruel. We don't know what caused the dog's death. So that portion, that enough, requires you to return a verdict of not guilty. And if this is the last time I'm going to speak with you. The state has another opportunity to come back up in here, and they're going to discuss some of my points. They may bring up, maybe they won't. Dr. Perlman testified that the first hack, whoever did this, caused a paralysis. If you believe that, there's no pain and suffering. If you believe that. Which there's no reason to even get that far, to be quite honest. But again, we have the problem. They have no idea who did this, and it was their job to show you. Cruelty, you don't even need to worry about, the state conceded it. They said, decapitation. They said it themselves, I'm not just making that up. They said, no, we don't got to worry about cruelty. Remember the jury, the dog had his head decapitated. But that's not what caused the death of the dog. So again, that's more reasonable doubt. It falls again. Let's look at the lesser included. Animal cruelty. I'm just going to show it quickly because even the state said it's practically the same thing. And when we mean the same thing, it's just more reasonable doubt. To prove the crime of animal cruelty, the state must prove beyond a reasonable doubt. Domingo, we have an issue with identity. Who did this? Unnecessarily mutilated or killed? Well, we don't know that because we don't know cause of death and we have no evidence that he did this. So you have to find him not guilty of the lesser included as well. Now, the second charge, unlawful disposal of a dead animal. We have an issue with Domingo Rodriguez again in all these crimes. Disposed. No evidence that he disposed anything. No evidence whatsoever. Obviously, they're going to say, though, he saw him at the park. Okay, what happened at the park? That's reasonable doubt. Was he with people? Did he go fishing? You saw the fishing pole in the back of his truck. Did he go fishing? Did he drop the dog off there? Did he have the dog? Did somebody else do this? Those are questions. Those are fair questions. They needed to answer them. What happened inside the park? No tire marks, no investigations. No investigation was done at the park. That's assuming that the dog was left there, which we know. Just refer back to the wise words of the young fisherman. You drop something in the ocean, it's not going to stay there. It's like a message in a bottle. You get a little bottle, put a little message in there, you drop it somewhere off the coast, probably ends up somewhere in China. The message in that bottle is not guilty. So we don't have public road or right of way, because if just for the sake of argument, if you're to believe that the mangroves were it, the mangroves is not the right of way and it's not a public road, so you're left with in any place where such carcass can be devoured by beast or bird. We do not know where the animal was dropped off or by who. There's no fingerprints, there's no DNA on the back. Nothing. So this has to be a not guilty. There's a lot of people in this courtroom. Don't let them pressure you. Your job is very simple. What are the facts? What are the law? If you have a suspicion, okay, it's fine. But a suspicion is not enough to convict a man whose liberty is at stake. If you're curious, okay, it's fine. You all are human beings, but that's not enough. You need to have facts. And the state is going to get back up here and they're going to reiterate. Adoption, seen at the park, and inconsistent statements. Inconsistent statements, you know when those were made? At 2 o'clock in the morning. Oh, he had something to hide, members of the jury. If he had something to hide, why would you let a law enforcement officer in your house at 2 o'clock in the morning, show him inside your house, show him in your back patio? That's not a man who wants to hide something. Because think about it, he was not there at the home. He did not have time to organize his home. He had nothing to hide. He was a law-abiding citizen that when asked if they could come in, he said, yeah, come in. 2 o'clock in the morning, I think my wife left the door open. Or he could have got it under. Think about the circumstances when those statements were made. Inconsistent as to how the dog escaped? Yeah, I'll give him that. But common in all those explanations that the dog escaped. This is the verdict form. Obviously, the judge made mention that there's a typo error. I wrote it. I wrote the D in to make it Domingo Rodriguez, but it's going to be substantially in the same format. You're going to have to only pick one of these, okay? Based upon the law and the evidence, this C needs to be marked. Not because I'm telling you, but because the law mandates it. The law requires it. There's no evidence here, members of the jury. I can't say it enough times. And the same for the second count. It's going to be B. The defendant is not guilty. Your verdict should not be based upon feelings or emotions. It has to be based upon the cold, hard facts or the lack thereof. And we have a lot of lack in this case. They had a heavy burden and they barely got off the ground. Doesn't matter that they brought 20 people in here. It was a lot of nothing that they testified to. All those witnesses, I would argue, we could have called them and it would have helped our case. There's nothing in their case that establishes that my client is guilty of this offense. And for all those reasons, as I just demonstrated, we're asking that you follow the law and that you find my client not guilty of both counts in this case. Thank you.
All right, thank you, sir. Members of the jury, we're going to take about a 10-minute comfort break. We need to do some other business, and then we'll come back in for state's rebuttal close. Thank you. Please take the jury out. I got to go down to grand jury.
stay here, if you could stay here.
Yeah, let's hear it.
You know, I'm not leaving this here too. So if you leave here, I don't want you to hold here.
I don't know how much time I took. Okay. Yeah. Then yeah, another half hour. I know. So, almost there. God, I can't believe I freaking stopped. Nobody knows it. I didn't notice it. So embarrassing. Face went all red. I can feel it. Yeah. Yeah, sure.
We just took a break. Can I step to the back for a second? I didn't get a chance to ask if these what's in here, but we're gonna do this in these are all, these all in order for you.
Yep.
So, I guess they're at the bottom, right? So 7, 8, 9. 7, 8, 9. Well, just so you know, so they'll be at the bottom.
Я не можу вийти з копчу, а тут адрес мене. Що там? How's little thing?
It's in custody.
Okay.
Так. Ще є окей. Ще є температура. Чоловік, якщо виплатить, то порадити. Самого зараз легше стане. Apparently, в мене... Hold on. 1 second. Ліпше чути? Окей, that's good. Він просто не може з корту вийти, бо там лежить в мене evidence, не може його лишати. So, виходить, що child вчора остався, ту жінку, що була в child, тому вчора. Вони додому писали, а мене поставили. So, it's possible, що я буду мати overtime. Це як кого платить. But we'll see, як воно буде. I'll call you, коли в мене буде break, okay? Я в мене десь, але я не можу сподівати. So I'll call you. When the jury goes out. The jury. Okay, honey? Hi.
That's what I told them. That's what I do it all again? No. Yeah.
All rise. Circuit court's back in session. All right, thank you. Be seated, everybody. Go ahead and bring the jury back in, please. Your Honor.
Your Honor, can I first with the correct verdict forms?
Yes.
Your Honor, would you be willing to give me a 5-minute warning?
Yes.
Thank you.
And the state utilized 21 of its 60 minutes,
Maybe I
so
won't.
you have 39 minutes.
Thank you.
Your Honor, the jury is present and seated in the jury box. Thank you. Does the state wish to give a rebuttal closing argument?
Yes, Your Honor.
You may proceed.
Thank you. May I please report? Counsel? Members of the jury. Defense counsel is 100% right. The state has the highest burden, and we welcome that burden, and we welcome proving the case beyond a reasonable doubt with circumstantial evidence and testimonial evidence alone. What that means, though, is that we know that we're going to have to bring witness after witness after witness to give a little piece to add to the case. A little piece that we're confident that at the end of closing arguments, you will have the common sense to put those pieces together and find the defendant guilty. If we didn't call in each family member defense counsel would be up here saying, we don't know who was in the house. We don't know if they did it. You've heard they didn't do it. Most of those family members didn't even hear about Dexter until after he was dead, until after law enforcement was involved in the case. The defense counsel said, we don't want you to see the whole picture. I couldn't be farther from the truth. You heard from Dr. Broman, you heard from Detective Payton, and you heard from Specialist Sedor because we want you to see the whole picture, even if it's not as pretty as we would like it to be. Let's talk a little bit about Dr. Broman. She said no toxicology was done. Imagine all the toxins, all the poisons, all the gases out there, and she told you there is no one single test all test. They need to know where to start. And think about how decomposed that body was. As far as the neighbor's bias, at the end of the day, what those neighbors want is justice for Dexter. At the end of the day, what those neighbors want is the best for Dexter. If they're giving testimony purely based on bias, wouldn't we think that they would be up here saying, yeah, I saw him. I saw him do this. I saw him do that. I saw the dog was hurt. But no, they gave you the facts as they knew them because that's what they were.
Excuse me, Your Honor, may the interpreters have a moment to fix the equipment?
Yes.
Thank you. Good to go.
I want to be clear what the state does and doesn't have to prove. The state has alleged that on or between May 10th and May 11th, 2024, these crimes occurred. We're not saying necessarily on May 11th. We're not saying necessarily on May 10th. Sometime in between. You're going to see in the elements, there's nothing that says specifically at this date and this time. The state does not have to prove that. The state also does not have to prove specifically at this address. The state has to prove the elements that come with those charges. And based on the facts that you have, we have proven that. We don't have to prove motive, but ask yourself, why decapitate a dog? A dog who perhaps is already dead. People don't decapitate dead dogs. People don't decapitate dogs. But this defendant, and that's what you heard from the witness stand, this defendant is the only person who had custody and control of Dexter the entire time from 5'10" to 5'11". It doesn't mean that Dexter necessarily was in his sight the whole time, but he's the one who was responsible. He's supervising Dexter. He's the one who adopted Dexter, and nobody else cut the head off Dexter. Also, as far as what the state has to prove, we don't have to prove pain and suffering. We have to prove pain or suffering. Okay? Suffering doesn't necessarily have to be physical. It doesn't say that in those elements, in that jury instruction. And you heard Dr. Perlman. Dr. Perlman didn't say the dog was dead when it was decapitated. She said she couldn't say. And why would we want her to say something, to give an opinion, when she doesn't have Dexter's head, to have a full picture? Why did the defendant let law enforcement into his home at 2 o'clock in the morning? Well, because he had several days to clean up any messes. We heard the home was immaculate. The backyard, nothing to note either. Why? Because there were several days after this occurred. The interview took place between 5:14 and 5:15. Dexter was already dead and was already dropped off 5:10, 5:11. And finally, the defense counsel has talked about gaps, missing pieces. imagining, I'm gonna talk about some gaps. Starting with some small gaps. How about the small gap of time between the time that Dexter, the defendant, adopted Dexter and the time that the defendant returned the crate? Now, not cool, not okay that he loaded the dog in that way and that's how he transported him. But then he brings back the crate. If that's the way he's choosing to transport Dexter, does he not need the crate because he's not going to transport Dexter any other time ever again? He doesn't even stick around to get the refund. Another small gap. My co-counsel already touched on it. That small gap under the fence. Dexter, not only did he have a cone on, he was supposed to wear that cone for several days. The defendant never took off that cone when Dexter was at the house. But Dexter has a little noggin. He has a head. This is not a small little dog. Okay? This is not a dog that's going to fit under that small gap. Another gap. How about the small gap of time between Dexter's adoption and the time that Dexter goes missing? This defendant adopted and lost a dog within less than 12 hours. Lost a dog. Another gap in the defendant's timeline, specifically when deputies asked about when he went to bed. He told them 10, 11. When did you wake up? 6, 7, 7. He omitted the fact that he was up. He was up in the middle of the night. There's an outgoing call that shows his cell tower, the cell site shows the device's location at 12/28/55 on on May 11th, 2024. There's another one, another data point at 12/29. Again, this is May 11th, in the middle of the night. He's at this home. And whose home is this? This is the home of the family members that you heard from. Several of them were from this home. They testified to this address, and they testified, I did not cut the head off that dog. They also testified, I didn't know about the dog. I didn't know about the dog until law enforcement was involved. Those two people were Fermin Rodriguez and Neda Conde Martinez. They didn't know about the dog. They were the ones living at that home at the time. How about maybe what you might call a gap? The notch, the indentation, that hesitation mark. That hesitation mark caused by something happening, something going wrong with coming down with that first blow. How about a dog moving when you come down with that first, when a person comes down, when the defendant comes down with that first blow? That could cause that hesitation mark. And as far as paralysis, would that prevent suffering? No, not necessarily. Paralysis doesn't mean entirely paralyzed. It doesn't mean he's not still aware of what's going on and what's happening to him. Paralysis, physical paralysis, does not paralyze Dexter's fear, Dexter's emotion, Dexter's suffering. How about, it says a crucial gap. The gap in time on the defendant's phone, his data, his search history. A big, and maybe not big in length, crucial, big gap. The entire trial, you guys heard, your members of the jury, you all heard me and my co-counsel asking about May 10th, May 10th, May 11th, May 11th, over and over and over again. And when is it that his phone doesn't have any search history? May 10th through 12th. Finally, this is maybe not so much a gap, but a distance. the distance between the defendant's home and where Dexter is ultimately found. This distance is not a coincidence. In fact, what defense counsel is asking you to do, they're asking you to speculate. They're asking you to believe that this defendant was so unlucky that first he adopts a dog, he's so unlucky that that dog goes missing within 12 hours. And then he's so unlucky that a random person finds the dog. And he is even more unlucky that he finds the dog and he decapitates his dog. And now defense wants you to believe that he's so unlucky that that random person who decapitated his dog now left the dog miles and miles away at a very specific location. And he's so unlucky because just coincidentally, he also goes to that location at the time that his dog is missing. I will concede he is unlucky. He's unlucky that he didn't cut off the microchip with Dexter's head. Because if that microchip wasn't there, who would know who Dexter belonged to? Who would know that headless, floating dog belonged to? So he's unlucky in that regard. Members of the jury, the state asks you to rely on your common sense. And if you feel that there's any gaps in the evidence, fill that gap with common sense and find this defendant guilty on all counts. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. And it says kindly leave those devices on your seats, but what we're really going to do is have the bailiff collect them from you in the jury room, and they'll put them in a little basket or box outside the room. And they will be guarded by the bailiffs while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. May I have the attorneys to the bench briefly, please. Members of the jury, with the exception of the 3 gentlemen on the end who are our alternate jurors, that'd be Mr. Yahia, Mr. Reeser, and Mr. Mitchell. The remaining 6 of you will now retire to deliberate your verdict, and I'll ask those other gentlemen to remain behind. If you have property in the jury room, we will go ahead and get that, but I need the 6 jurors to be taken to the jury room at this time. Here are the instructions and the 2 verdict forms. Thank you. Please take the jury out. And the jury's outside the hearing in the court, and Mr. Mitchell, Mr. Reeser, and Mr. Yahia, being alternate jurors sometimes kind of feels like going to the fair and waiting in a big line to get on a rickety ride, and you get up to the front and the person says, "Sorry folks, the ride's closed right now," and that's kind of like what being an alternate juror can feel like sometimes. So I apologize for that. In consolation, we do have a certificate for each one of you, along with a letter from me, and you can put that anywhere you want on your cork board or in your circular recycling bin. Whatever you want to do with it is up to you. If you need anything regarding your jury service, things for work, or simply you have questions about the outcome of this case, feel free to call my office. I also extend an invitation anytime you want to come down to your courthouse and watch court proceedings. Please feel free to do so. It's very important stuff that we do in this building, and it's all open to the public, and I encourage you to visit back with us in the future. There is an outside chance you may be summoned back here to serve on this jury if something were to happen to one of my 6. So please don't leave the country or anything like that so we can locate you. With that, I have nothing else for you folks. You're excused with my compliments and thanks. Have a good rest of your day.
Thank you, Judge.
Just leave your notebook, put down on the thing, make sure you pick up your chair badges for me. Then I'll have all the envelope for details and take it. Thank you. Thank you.
All right, it is 12:30 p.m. The jury is out. We'll be in recess pending call of the jury. Thank you.
All right, please. Court is in recess, please call by the court.
Are we doing the sentencing this afternoon? Thank you.
You're welcome.
We definitely don't know what's going to happen as soon as they come back. Right, exactly. We're going to some of this all the way over here, not.
You and got to, like, our list as possible to watch that for.
Right.
And just
We have
Man, get out of here. In Brooklyn's telephone. Brooklyn. Yeah, that's true, that's true.
Oh, I see.
Is everything okay? Just make sure I have all numbers. Let me just. Sorry. No, you're fine, I know. When you're done, can you take the Davidson in the jury room?
Yeah. Just need that right now?
No, with the evidence.
The evidence.